Indecent exposure. What is it? What does the state of Texas have to prove for the crime of indecent exposure, and what does it actually mean? Hi, I'm Jeff Hampton with the Fulgham Law Firm. Today I want to talk to you about the crime of indecent exposure. There's a lot of really bad examples and misunderstandings about what this crime is. And there's a lack of understanding of how serious it can be as well, because believe it or not, if you're not careful, there are times people have had to register as sex offenders because of the crime of indecent exposure. By the way, if you wait around to the end of this video, I'll also give you a free ebook, What to Do If You Have Been Charged with a Crime in Texas. Okay, so let's examine what is indecent exposure. Number one, under Texas Penal Code, section 21.08, the state of Texas is required to prove the following elements beyond a reasonable doubt. And here's what it says. A person commits the criminal offense of indecent exposure if he exposes his genitalia or his anus or with the intent to arouse or gratify the sexual desire of any person, and he is reckless about whether another person is present who will be offended or alarmed by his actions. Now, we're going to unpack all that here in a second, but the first thing we have to unpack is, what does it mean to be reckless? Okay, under Texas law, reckless is defined as someone that is aware that their conduct can cause the result of their actions, but consciously disregards the risk that the result of that conduct will actually occur. All right, now the only way to really jump into all this is just to start talking about some of the legal defenses, because generally people say, well, so if I expose myself to someone else, that means I'm guilty. No, not necessarily. Okay, there is a portion of the law that's only a Class C ticket where you can recklessly expose yourself to someone else where there's no sexual element involved in it at all. Okay, so let's talk about what this means. Defense number one is the state of Texas not being able to prove that you acted with the intent to arouse or gratify another. Now, this is probably the most litigated portion of this statute. Anytime someone is charged with indecent exposure, this is where we find this to be the case, okay? So what does it mean? It means here that the state of Texas must prove that the individual being charged, that the accused, intended to arouse or gratify the sexual desire of another, and whether or not that individual acted recklessly in the process of doing so. So one of the things that we see as an example, and I can only tell you, use some of the examples that we've dealt with here at the law firm, is we had an elderly gentleman. He was in his 70s, and he had some dementia that was coming on. And he actually went to the convenience store. He was an elderly man going there, and he literally exposed himself while standing in the line to pay for something, okay? Well, you can imagine the clerk was pretty freaked out. Like, what is going on here? Immediately picked up the phone, called the police. The police come out there. Our client's super confused. He's got dementia. He's not sure what's going on. Well, they arrest him for indecent exposure, okay? And so one of the things we're looking at is we're saying, hold on a second. Fine, he exposed himself. But can you prove that he exposed himself with the intent to arouse or gratify? Okay? And what I mean by that is it's the same thing with urinating in public. In both instances, I'm just going to tell you, for a man, it's real clear. If he's doing it to arouse or gratify himself, you're going to be able to see an erection. I'm just saying the way it is. Okay? If he's attempting to try to arouse or gratify someone else, usually there's some type of, he's trying to say something to arouse that person. He's trying to do something to direct his behavior and his actions towards the other individual that is observing this behavior. Otherwise, you don't just infer it. Someone that is exposed, it does not mean you can just infer that they were doing it with the intent to arouse or gratify, okay? So the state of Texas must be able to prove that element beyond a reasonable doubt. And so in the example of our elderly client that we represented, he may have committed the crime of the Class C Misdemeanor of disorderly conduct by exposure. Because under Texas Penal Code section 42.01, the offense of disorderly conduct by exposure requires that the state prove that you intentionally or knowingly exposed your genitalia in a public place and were reckless about whether another person would be present and offended. Well, yeah, so he did do that. But understand what a Class C offense is. That's a ticket. It's the same thing as a traffic level offense. That's much easier to get dismissed and removed from your record, okay? So in that situation that we talked about, the state of Texas, we pushed them. They were going to end up having to, at that point, drop the charge from the more serious indecent exposure down to the lesser charge. And that allowed him to be able to get that off of his record later and help him avoid being convicted of a crime that looks like it has a sexual element to it. Because that's the worst thing about an indecent exposure charge. Even though there's no rape, there's no molestation, there's none of that going on. It's not, there's no pornography, there's nothing like most people think of. But under Texas law, it's categorized under the sex crimes designation. And we're going to talk about that here in a minute under the punishment section. If you're not careful, you stack up a few of these charges, you can end up registering as a sex offender, okay? So that's one of the things that we talk about. Now, another problem scenario where the state of Texas may not be able to prove intent to arouse or gratify is when there is no evidence of sexual arousal. It's a different situation with a woman in that situation, but there must be specific evidence. You don't have to prove anything. The state has to bring evidence that establishes this, and it cannot be inferred. Otherwise, your attorney needs to be fighting that, all right? Now, defense number 2, the inability to prove recklessness. So even if someone did act in exposing themselves with the intent to arouse or gratify themselves or another person, the state must also prove, there's the and language, right? So they must prove that both it was done and that it was reckless in the way that it was done, all right? So what if the activity was done negligently? What if it wasn't reckless? So, and the reason why I'm saying that is what if someone is doing this in the privacy of their home and their door or their window is open or their door is open, but yet based upon the facts of what's going on, there's no reasonable expectation that anyone would have seen that, okay? One example that we have is we had someone we represented they were doing some things to arouse or gratify one another in a tent at a public park, okay? Now, it's a public park, but there was no one else around except for the police officer, okay? So the question becomes, were they acting reckless in doing so? Maybe they were negligent. Maybe that wasn't the best place for them to do that, but they were not acting in a conscious disregard to someone else being present, or at least that's what our argument was, that made it more difficult for the state of Texas to be able to prove the element of recklessness, because it's not just negligence, it's that higher level of criminal intent that's required under the law, okay? Now, additionally, I want to go over for a few moments the criminal consequences for a conviction for indecent exposure. The crime of indecent exposure is classified as a Class B misdemeanor, which means it's punishable by up to 180 days in jail and up to a $2,000 fine. However, if you receive a second offense or conviction of indecent exposure, that now becomes a Class A misdemeanor, a higher level offense, punishable by up to a year in the county jail and up to a $4,000 fine. But here's the worst part. Taking that second indecent exposure charge, which is why you don't ever want to have a first, okay, now could require you to have a mandatory registration as a sex offender for 10 years under Texas law if you were convicted under that. And sometimes people will take a deferred adjudication on an indecent exposure second, and they'll say, well, that's okay, I avoided it. Well, technically you might have unless you violate your probation. So if you have a probation revocation and that probation doesn't work out, now all of a sudden Texas is going to come to you and say, you got to register as a sex offender. So it becomes a lot more serious when you start talking about registering as a sex offender. No one wants to be required to have to do that, okay? So this is why you need to make sure you hire an aggressive and experienced criminal defense attorney that has a track record of dealing with these type of offenses, all right? And so the number one, what are the goals here? Anytime that you're hiring an attorney, number one, you want to try to see if you can get the case dismissed for lack of evidence. These elements that I just went through with you, if there's reasonable doubt related to these elements, your attorney needs to push the case as far as it needs to go in order to try to secure you a dismissal because the state cannot prove their burden of proof. Now, the second option can be a conditional dismissal. Sometimes, even though the prosecutor may not be willing to drop it flat out because they're afraid for their supervisor, just whatever, they're afraid they're going to get in trouble for dismissing a case, sometimes they will agree to do a conditional dismissal where if you do some community service up front, maybe you take a class, they would then agree to add that to their file in exchange for a dismissal. Both of those dismissal options allow you to get that off your record. You'll still be eligible for an expunction. The other option I've already mentioned is to drop the case down to a Class C misdemeanor. We've had many, many indecent exposures where we were able to poke holes in the situation where, as it relates to the intent to arouse or gratify or the reckless element, and drop that down to a Class C misdemeanor, disorderly conduct by exposure, that under a deferred disposition under that arrangement, you can still get that off your record. So you're still being able to check all the boxes off your goals on that. No jail, no conviction, get it off your record, okay? Finally, you can always take a case to trial. We've had a number of cases where we've taken to trial based upon this indecent exposure element, because see, people just freak out. If someone exposes themselves, they immediately say, oh, they just jump to conclusions. But the state of Texas, the Texas legislature has identified these specific elements that have to be proven. And just like that poor elderly gentleman that we represented, can you imagine if he had to taken a conviction for that? The man had dementia. And so we needed to make sure we stood up to the state to make sure that it was handled properly. But listen, maybe you or a loved one is facing this crime in the North Texas area. We would be willing to provide you a free consultation and a free case analysis if you want to give us a call at this number that you see above me that's been up here the entire time. Give us a call. We can schedule that time to go over this with you. And I also want to invite you to take the free ebook that I offered you earlier, What to Do If You Have Been Charged with a Crime in Texas. Click down into the description portion of the YouTube video. Give us your email address. We'll send that over to you, and we'll be happy to help you. I hope this video's cleared up a little bit for you, exactly what's required. You don't want the state of Texas running over you when you're innocent. Thanks for joining us here today. We'll be sending you more content like this. Subscribe to our YouTube channel. Like this video if you enjoyed it.